My name's Chris Corpus. I'm a local business attorney here in the Cleveland area. Um, been doing this heavens for 25th anniversary coming up. Graduated law school back in 2000, went to Case Western Reserve, worked for a few different law firms over that time period. Back in 2016, I decided to become an entrepreneur, just like you all in the audience, and started my own law firm. And I've been doing that since 2016. And since 2016 through now, I just do corporate and business work for clients. I just do contract drafting and review, commercial real estate, buying and selling commercial property, leasing from the landlord or their tenant perspective, commercial property, and also trademarks. So I also consider commercial real estate, excuse me, um, buying and selling and leasing residential rental properties. Since you're not living in that property, I don't consider that to be a residential property, even though it is a house. But since you're going to be running a business through that house, I consider that to be commercial real estate still. Anything else that comes in the door, I refer out, whether it's domestic relation, litigation, probate, you kind of name it. I just focus on those areas. So that's helping people start businesses, do business with partners, um, buying and selling businesses, drafting, reviewing a different variety of contracts, and then, like I mentioned before, commercial trademarks. And today we're going to be talking about contract review. So here's what we're going to be talking about today. What are the elements of a contract, types of contracts, contract content, and payment terms? All right. So the elements of a contract, you have offer, acceptance, consideration, capacity, and the subject matter of the contract must be legal. So we'll talk briefly about those items. So the offer. So you can make your offers a couple of different ways. One would be, do you want to buy my car for $500? Um, I'm asking you to affirmatively make a response as the buyer that you say yes or no. The other type of contract is, I will give you $500 if you drive my car to Akron. No formal acceptance needed for that type of contract because the acceptance is, you just getting in that car and driving it to Akron. So both of those, there has to be an offer made. And then acceptance. How can you accept an offer? So does the offer itself say you have to accept the agreement in this particular way? That you have to accept it via, the U.S. Postal Service, via email, via some written document. How does that offer limit how you can accept that offer? And then does the offer specify a particular type of acceptance? And so that would also be, kind of, just literally the fact of you driving that car to Akron, will that be acceptance? Or is there any other particularities? Like you may have a customer engagement agreement that you use, and you want to make sure that you understand that it's very clear that this customer has accepted. Sometimes people say, well, hey, if you don't respond by a certain day, that means I'm going to deem that you've accepted my offer. And I'm not a big fan of those because I want to make sure that, there's no misunderstanding. It's very clear that the other side had to do something to accept, and it could be, somehow responding. It could just be an email or a text message saying, yes, I accept your offer. Let's move forward because, everybody wants, I mean, the whole goal for contracts is clarity. What do business owners crave? It's not profits, it's not, certain amount of cash or revenue, it's certainty. That's all a business owner wants. That they ultimately want to know for sure what's going on. Has this person accepted my offer? Can I start doing work? Because the worst is you start doing the work and then ultimately the customer goes, well, I never accepted. You're like, well, yeah, you did. And you're like, no, I didn't. And you're like, well, remember, you were supposed to respond by a certain date. Like, I never got your email. Went to my junk folder, whatever it may be. And you just want that certainty because you don't want to waste time. And then can the offer be withdrawn prior to acceptance? In general, the answer is yes. So at any point in time, if you make an offer, you have the ability to rescind that offer before the other side has accepted, except if you make a firm offer. And that firm offer is, I'm going to keep I'm offering to sell you my car for $500 and you have until X day, October 1st to respond, right? That contract's open until October 1st. You do not, as the offer or have the ability to rescind that contract prior to October 1st because you made a firm offer. So that contract has to be open until October 1st. This is a bit outdated since no one uses the US Postal Service just about anymore, but there is something referred to as the mailbox rule. Someone makes an offer, says, I want to sell you my car for $500. And then on Monday, you drop a letter in the US mail saying, I accept. And then it gets to the offer or say on Thursday. On Wednesday, the offer or contacts you and says, I rescind. I never heard back from you. You're like, oh, no, 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 no. I dropped my acceptance in the mail to you in the US Postal Service, and you should get it any day. And it's postmarked Monday. So since your acceptance went into the US Postal Service on Monday, that's the day of acceptance. So the offer, or even though they haven't received that acceptance yet in the mail, cannot rescind because you've already accepted. And I believe the corollary of that would be true if you send an email accepting, and then later that day they contact you to rescind. You've already accepted. The whole point is the acceptance has already been made. Once you've accepted that, now we have a contract. And then I mentioned here, is the offer open for a certain number of days? And that's that firm offer, which we just talked about. Then I have that big fat emoji of a thumb pointing up. So you got the thumbs up emoji. There's a case out of Canada that ruled that the thumbs up emoji in response to an offer, do you want to buy my car for $500? Thumbs up. That's an acceptance. That was the mental intent of the offeree or the buyer that they intended to purchase. So they didn't even have to use a word. They could just use the thumbs up emoji, and that was considered the intent of the party, and they found that to be a enforceable contract. So you have to be careful what you put in text messages, emails, instant messages, social media. All of those are writings. It doesn't have to, and I talk about it maybe on another slide. You don't have to have a formal 8.5 by 11 piece of paper that says contract across the top to have an enforceable written agreement. So you do have to be careful. And you can also, by your actions, amend your agreement without necessarily realizing it based on emails or text messages that go back and forth between the parties. All right, elements of a contract consideration. Each side needs a detriment. And what does that mean? So each side in general needs to be giving up something. So it's very easy in the car example. I'm giving up my car, and you, as the buyer, are giving up your money. In exchange for the car, I get the money. In exchange for the money, you get the car. So each side has a detriment. Each side has given up something. But consideration doesn't only have to be money. Consideration can be, I'll pay you $500 if you don't cut your grass for the month of June or the month of May, which that was all the rage for a while. And so, you agreeing to forego doing something is also consideration. The fact you could do something and you chose not to is also considered to be consideration. And then amendments. Like I mentioned before, you generally you want your contractual agreements to be in writing, and then if you have an amendment, you want that to be in writing. Does it have to be in a formal document that says amendment across the top, 8.5, 11 piece of paper that both parties sign? No, but it should be very clear that once you have agreed to whatever the change is, that it's in writing and both parties understand it. The whole point of a contract is clarity. The goal is not to have um, interpretation. So if you have to go back through like a whole thread of emails to figure out if there's an amendment or not, you're better off cutting and pasting and putting up, the offer, the amended offer, and then underneath it say, yes, I accept this, or just something to that effect, as opposed to, because the goal, the hope is that you never have litigation regarding this contract. But if you do, you want to be able to sit on the stand or in a deposition and very clearly say what the parties have agreed upon or what they didn't agree upon. Um, so, that's the hope of any type of amendment that, there's no surprises here. And then any pre-existing obligations. So you just have a very basic contract. Someone's going to do some work for you at your house, going to put an addition on, 10 grand is the contract price. And then the builder comes back, the contractor comes back and goes, you know what? It's actually 14,000. You're like, what are you talking about? You're like, just misquoted. It's 14 grand. Are you doing anything different? Nope, same work, same job scope. And you're like, but you just want $4,000. We have a contract. You want $4,000 more for doing the exact same thing. Nothing different. I didn't ask for any change orders. And the contractor's like, yeah, I just misquoted it. And then ultimately, so no, if you have a pre-existing obligation, there's no consideration then for that amendment or that change. So that requested amendment, if you don't agree, and then the contractor stops work, the contractor's in breach because the contractor had a pre-existing obligation to finish that work for the $10,000. It'd be different if there's a clause in there that says, escalation of materials. Then that would be maybe a little different story. Hey, I quoted this, a year ago, and lumber was $1 a square foot, and now today it's $1.90 a square foot. So that would give them the ability in the contract to increase the cost of the materials, but not their time. Um, so that pre-existing obligation need to be reviewed. So if the contractor abandons the job, now you have to hire a new contractor to finish it. Your position is still original contractor, you're in breach. So that if you have to finish the job and pay a new contractor, say $13,000, $3,000 more than the original contract, then you would have a claim back against the original contractor for $3,000, the amount you paid over and above the original contract. All right, elements of a contract capacity. So, in order to be able to sign an enforceable agreement, um, all contracting parties have to be 18 or over. So, if you are in the business of dealing with minors, you could be like a coaching service, a physical fitness service, a tutoring service, something to that effect that your client is actually the minor, then you're going to need a parent or a guardian to sign that contract on behalf of the minor, because the minor's signature, the minor signing that contract would be unenforceable. But you could still have the minor sign the agreement, acknowledging the terms and what they've agreed to, but you need to have that parent or guardian sign that contract on behalf of the minor to be enforceable. And then mentally capable. The person has to have the mental capacity to understand what they're doing, that they entered into this contract, that they're hiring you for a particular service, that they understand the scope of what is going on. This happens a lot with elderly, right? They're like, say, hey, pay us all this money and we're going to write your autobiography. And they're like, what? Okay. And they have no idea. They have some sort of mental decline and they really don't understand what they're doing or what they've agreed to. And so then the issue comes down to, did that person have the mental capacity to sign that agreement? And it could be someone with a diminished mental capacity that someone's trying to take advantage of. They have some sort of disability and they really don't understand or can appreciate what exactly the contract says or what they've agreed to. So that mental capacity is going to be an issue if someone says, hey, that you don't have an enforceable contract here because this person was mentally not able. And you'd look at doctor's records and maybe some history if they have any type of support from schools or anything like that. And then the subject matter has to be legal. So in order for you to have the enforceable contract, along with all the other elements, the subject of the contract can't be illegal. And so it's like, okay, I'm going to give you $1,000 to buy an illegal drug, steal a car, whatever it may be, and they gave you the money in advance, and then you're like, well, I'm not really going to steal the car. And then they're like, okay, I'm going to file a lawsuit against you because I gave you the money to steal a car and you didn't steal it. Um, the court would say not an enforceable contract. The subject matter was illegal. And so there may be another way that you attempt to get that money from the person who didn't perform the service, but it's not going to be through the legal court system. Um, and it also could be, you say, I'm going to provide medical service for you. I'm going to apply legal services for you, and I'm not a lawyer. right? I mean, the subject matter of your agreement is also illegal, right? You don't have the licensing to provide medical services or legal services. And so that would also be an unenforceable contract. All right, types of contracts, written versus verbal. And I don't, yeah, so verbal agreements enforceable? And the answer is in general, yes. What's the problem with a verbal agreement? What are the terms? Don't you remember we were standing there under the tree on 4th of July and you said blah. And then the person goes, no memory. And you're like, come on, don't you remember? We were all at the same place. And you're like, no, I don't remember. And you're like, oh, come on, now you're lying. You're like, yeah, I'm lying, but I don't remember. And so, how are you going to prove that they're lying, right? That's a problem. And so, that's the problem with verbal agreements. It's the he said, she said thing. So, while verbal agreements are generally enforceable, it makes it difficult to know what the terms are. So, there are some situations when verbal agreements are not enforceable. And that's when it's for the contract of a sale of goods, and the sale of goods are $500 or more, that has to be in writing. Doesn't apply to services, just to the goods being sold. Typewriters, who uses a typewriter anymore? Computers, whatever it might be. And then any contract relating to real property, a lease, you want to sell your property, anything like that. If it's not in writing, it's not going to be enforceable. So I generally recommend to clients, let me just move forward a slide. Yeah. So I generally recommend to clients that if they do have a verbal agreement with someone, and I may have this later in the slideshow, um, that there's two things that you can do, and I do think I have this later, but I'm going to talk about it now. Um, Respond back to them in an email, text message saying, "Hey, great talking to you. Nice conversation. This is what we talked about. If anything in this email is incorrect, please let me know." So now we at least have a written record of what was discussed, not a contract, not an offer, not an acceptance, just memorializing the conversation. And then if there is a dispute, now you have something to rely upon in a court hearing to say, hey, the other side goes, we didn't have a contract. You're like, okay, I sent you this. You never you my text message and you never responded to say it's not correct. And then the judge goes, did you receive this text message or email? Yeah, I did. And did you tell the other side that it's not correct? No, I didn't. So now you don't have a written contract, but you have some proof as to what the terms were. And more than likely, the court is going to look more favorably on the person who memorialized the terms as opposed to the person who just received it and ignored it. They're like, well, why didn't you respond then if you didn't agree? So you must have then received it and you must have agreed. And now you're just trying to say, I don't agree for whatever reason it may be. And the other response is send an email saying, here are the terms of the agreement. I'm not going to start work until you respond and say, yes, that's correct, or something to that effect. So now we're taking our verbal agreement and we're actually turning it into a written agreement where now I'm making the offer and then you have to accept. If I don't hear back from you, I'm not going to start. I'm not going to commence work until I hear back from you. And when that person responds back and says, yes, that's all correct, now we actually have a written agreement through your email chain. Written agreements does not have to be formal, does not have to be like I mentioned before, an agreement, an 8.5 by 11 piece of paper with agreement written across the top of it. It could be on a napkin. You're out in the wilderness doing, talking about whatever. You're going to sell someone a piece of land. You're looking around. You're like, I don't have any paper. Don't have any napkins. You're writing on the bumper of your car. And both people sign it. Is that a writing? Sure is. Problem is now you have to take the bumper off your car, right? You don't want it to the rain to wash it off. But it's a writing. Assist with clarity. The whole goal here, very, very rarely, maybe a 0.5% of the time, do I have clients that actually want to have ambiguity in their agreement. They want to have some wiggle room, knowing that they might have litigation, they may have a fight, but they want to have the ability to have a little bit of ambiguity and a little bit of wiggle room for interpretation. But the generally the goal of the contract is for all parties to know exactly what the obligations are. You should be able to give this to a seventh grader, and the seventh grader should be able to read it and go, "Okay, I know what you're talking about. I know what's going on here." Don't want to leave as few items to interpretation or assumptions as possible, and obviously that assists with clarity. Rights and responsibilities and obligations should be very clear in the agreement. When are you going to do something? When is it going to be completed? Are you given any representations and warranties that this product or service will do something in particular, will provide a certain level of comfort, operations, whatever. You just want to be very clear. Or are there no representations and warranties, as is, where is, take it with all faults. But that should be clear in the document. And then this is where you follow up, your phone call with a text message or an email confirming the terms, or that you won't start until I respond and until you respond and I hear back from you. All right, contract content. To me, this is a huge deal. Do you understand all the provisions in your contract? If that contract's 10 pages long, that thing's not a paperweight. It's not meant to be sit on your desk and keep things from blowing away. Every provision in that contract has a purpose and a meaning. Generally, it's there to shift risk or apportion risk to one party instead of the other. Maybe limit liability of one party. And so you do need to understand the contract. I had a client, she was like, I read the contract. I'm good. Just give it a once over. I'm good with everything in it. And she was a distributor. And the contract was written so that this is a contract between my client and the manufacturer of the product. And my client did not alter the product. So the contract was written that if anyone got injured from the product, my client, the distributor, would be liable to the customer and also indemnify the manufacturer for their manufacturing of a defective product. I'm like, that's nuts. I'm like, that sure seems backwards. And I told the client, I'm like, is this what you read and this is what you want to agree to? They're like, why would I ever agree to that? I'm like, I don't know, but you said you were fine with all the terms of the contract, but that provision's kind of weird. I think it's backwards. And then she was pissed. She was like, why would they do that to me? I'm like, you know what? I don't think they meant to. I think they took this document from another, from a prior usage or another usage, and they just continue to use this contract, cut and pasted it from another agreement. I go, I don't think this was intentional. And so she contacted the manufacturer. And they're like, oh, no, no, no. Why would you indemnify us for our defective product? And she was like, I don't know. It's in the contract. They're like, oh, no, my apologies. We got it wrong. Because that was just a mistake. But if it wasn't reviewed and wasn't caught, if heaven forbid something happened contractually, my client would be defending the manufacturer of a defective product. And again, do you know what all the provisions in your contract should mean? If you ever read a provision, you're like, I don't know what that meant. Then you need to have it reviewed. Um, and so, it's important that you understand every provision in the agreement. Some are pretty straightforward when you read, you're like, oh, yeah, I know what they're talking about. And other ones are like, wonder what that means. And sometimes it's a term of art. It's a legal term of art. Like I was helping a client with a lease. My client was the landlord, and there was a provision in the contract that the tenant was not supposed to commit waste. And the tenant had an attorney review the contract, but obviously she wasn't, he or she, the attorney reviewing the contract was not familiar with commercial leases. And the attorney writes back on the document, who's putting waste on the property? Who's bringing waste onto the property? What are you talking about? This provision makes no sense. And I'm like, oh, no, 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 no. This is a term of art in commercial real estate, even in residential real estate. It means you're not supposed to diminish the value of the property. When you leave here, the property should be worth the same amount as it was when took over this lease. And so you want to make sure that when you review the provisions, you understand what they mean. And it could be a kind of like a term of art. And then kind of as an aside, if you do go to hire an attorney, maybe it's from a recommendation, referral, someone you see, someone you know from a prior case. I always think it's important to go to that attorney's website to see what they list as their core competencies. If you find someone that does divorces, child custody, child support, automobile accident litigation, and then you have a commercial lease that needs to be reviewed, you say, hey, can you review this commercial lease for me? Sure. How many times have you done this before? You're the first. And you're like, oh, really? I wonder if there's any attorneys out there that this is something they do often. And so that's what you want to make sure that you hire someone as your attorney that does have experience in this. Like, I've never done a divorce, and you wouldn't want me to handle your divorce for you. And I know attorneys that's all they do. And so I'm happy to refer you to someone who does domestic relations for a large proportion of their work. So it is important to ask those questions to make sure that they are familiar with your area of law that you're seeking help in. Then no blanks. If your contract has a blank in it and you sign the agreement, the other side can fill it in, and you've agreed to whatever the other side wrote in that blank. Could be a closing date, could be a price per unit, could be a quantity, whatever it may be. If there's a blank and you sign that contract with a blank at your own peril. The other side can fill in there what they believe is, supposed to be in there, and you're not going to really have any recourse. So the point is, do not sign a contract with blanks in it. Now it's different. Maybe if it's, this contract was executed on September blank, 2025, then, obviously the date's going to be put in there. So it's going to be the day that you signed or the day the other party signed. But other than the date, I would not be signing a contract blank. And quite frankly, if the contract had a blank for the date, I'd be writing in the date that I signed. Um, so, all right. Contract content, artificial intelligence, and forms off the internet. So forms off the internet, and artificial intelligence creating a contract for you, would these be legally enforceable? And the answer is, as long as you executed it correctly or as required. Some documents do need to be notarized for them to be enforceable, but there's not very many of those. So as long as all the parties properly executed the contract or the agreement, it's going to be enforceable. And again, the question comes down to, what are the terms of the agreement? If it's a form off the internet, or you did a search and you find a contract from someone else's deal or transaction, then you may be like, I've just agreed to someone else's deal terms, and I don't know what they were, and I don't know why those other parties agreed to those terms, and why they didn't agree to some other terms. So, um, you'll want to, understand, so that's the problem when you pull a form off the internet, is you don't know why the other parties agreed to the terms that they agreed to. And are those the standard terms, for this type of transaction? Was that transaction, I have documents that are buyer friendly if I'm representing a buyer. I have documents that are seller friendly if I'm representing the seller. And so, the form that you got off the internet, is it buyer or seller friendly? A lot of times it has to do with the representations and warranties that you agree to make, to the other party, and the commitments you were agreeing to make. So you have to look to see, what are the terms here, and why were those agreed to initially? And you'll never know why, two other parties agreed to those terms in someone else's contract. So you do have to be careful, when you pull a form off the internet. In artificial intelligence, I do think there's uses for this. I do think there's benefits of this. But I've also used AI. Like I had a small research project, and I'm like, I wonder if I put this in artificial, run it through one of the AI services and say, please review this, research this, provide me the answer, and provide to me citations. And it gave me a brief blurb, a brief little, statement as to the research, and it provided two citations. And both cases existed, and neither case was dealing with the issue that I asked for. And so, both of the supporting case law had nothing to do with the answer that AI gave me. Um, and so, while it looked legitimate, it looked correct because it had this nice citation of a case after it. 100% wrong. It wasn't even right. And so you do have to really be careful. So you do have to check. You do have to review. Um, and when AI creates, if you say AI create me this contract, you don't know where it's pulling the information from. Um, and so you really have to be careful. You don't know why it pulled it. You don't know where it pulled it. You don't know what the database is. So you do have to be careful, about, having an artificially intelligence generated contract, or you just pull a form off the internet and go, close enough, right? I mean, it's close enough until it's not, and that's the problem. And once it's not, there's nothing you can do about it, right? I mean, presumably, there's some detriment that you're dealing with based on the way the wording of a contract is. And if you have a detriment, that means presumably the other party is somehow benefiting. And it might not be an improper benefit. It just could be that no one really, knew what this wording meant or the implication of this wording. And uh, the other side's not going to agree to a change or an amendment. It's too late now. I had a transaction with another party, and the other party, it was just a heavily, negotiated contract with, other legal counsel. And it all came down to whether um, there is an S on the end of a word, whether the word was plural or singular. And ultimately, the word was singular. And I believe the other party, when you just read it quickly without really analyzing every word, I think they just assumed that it was plural. And it had to do with whether the term of the agreement continued to extend. It was to extend for one term, singular. And the other side was like, no, 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 no. At the end of the year, this agreement renewed again a second time. I'm like, what are you talking about? I'm like, term was singular. It's not plural. And they're like, yeah, but the parties continued. The one party continued working and the other party continued paying after the end of the term. So the term, must have been plural. And I'm like, no, I don't believe that's it. I don't believe that's the right answer. They're like, well, why then what under what rule or law did the person continue to work? And the employer continued to pay. And I'm like, oh yeah, you went from a term of employment for a year plus 1 year extension under the contract. And then once that second year, that extended year ended, now you're an employee at will. Every time you show up for work, the person got paid once a month. Every time you showed up for work and the employer didn't kick you out, then you were basically an employee for another month. And then the employer paid you. And so that would confirmed, that the employer agreed that you're an employee at will for another month. Um, and so that, the employer just needed to give you 30 days notice to terminate, which the employer did. And they kind of went berserk, say, no, 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 no. This is it's another year, blah, blah, blah. I'm like, no, because there was ramifications for that. And so there was sort of a big deal that the employment was actually terminated because it caused other terminations also. Um, so anyway, you do have to be careful. And by no means, when the contract was drafted 2.5 years earlier, did anyone, try to slip something through to say, we're going to make this a singular term instead of a plural term. It's just that's what the parties agreed to. And so there wasn't anything malicious in that original wording, but it's just understanding what the wording is. So in essence, the person had a 1 year guaranteed employment. If no one objected, it would automatically renew for a second year. And from my client's perspective, they're like, I have an investment in this person. I want to make sure I at least get a year out of them. And potentially that second year. Like I'm actually hoping they stay and retire with me, but I at least need that 1 year. They can't leave after 6 months because I have too much of an investment in them. And then the person stayed for a second year. Um, anyway, so you do have to be careful. You have to understand and what you're agreeing to this because like I'll read a contract for someone and I'm like you have to read the contract as to what's said and what's not said. Because what's not said in a contract is potentially just as important as what is said. And so you do have to really be careful when you're reviewing that contract to understand explicitly what the parties have agreed to, and then is there any gray area that you need to address? Because again, the whole point is that contract should be just a written roadmap of what the obligations or rights or responsibilities of the parties are. So, all right, terms of payment. I think this is maybe one of the most important provisions in a contract, because if you're doing work and you're not getting paid or getting paid timely, you may be out of business, right? I mean, that's a real problem. So there has to be some understanding and certainty as to what's going to happen with payment here. So clarity, down payments, progress payments, how much is due at the end of the job. I was talking to one person and they're like, oh yeah, when I'm done with my work, building a website, whatever it might be, they're like, yeah, the customer owes me 50%. I'm like, have you lost your mind? I'm like, why are you doing so much work in advance and not getting paid? And then leaving so much due at the end that if the customer isn't happy, now you're really out a lot of money. So part of it is also just structuring, the amount of the down payment and progress payments for a big job. because you want to be able to check in, have the party agree or disagree with some of the work you've done, so you have shorter U-turns if the person's not happy, as opposed to going, okay, here's the final product, and you're like, well, that's not what I was expecting. You're like, but this is what you wanted. They're like, no, I don't know what I wanted, but didn't want that. As opposed to you checking in periodically, whatever makes sense in your situation to say, hey, this is what I produced. Is this what you're looking for? This is what I believe it was. And you're like, oh yeah, that looks good. Check off. Yep, they've agreed. And then you owe me another 10%. That I'm going to continue working. And then, yep, okay, check in again. Okay, you owe me another 10%. I'm going to continue working, whatever that is. But I think it's important to have check-ins in progress payments. How much of a down payment do you want? 25%, 50% to get going. And then, leaving 10% at the end of a job is, I don't necessarily disagree with that. Having 10, now you're only looking for 10% to be lost. That maybe is your profit. But you're not, 50%. You're like, okay, that's paying for my employees, that's paying overhead, and that's a problem if that's what's due at the end of a job. So you really want to make sure you're managing your cash flow, because then if the person goes, no, that's not what I want to stop, and now you maybe you only have 10% that's owed that you're looking to collect upon instead of a huge percentage. So I do think it's important to review over your payment terms, and if it makes sense with the work that you do, to break it up into progress break points. So the client looks at it and goes, "Yep," checks it off, looks good on our, everything looks, you're on the right path, and then ultimately go, "Okay, well then now you owe me another 10%." And it's very clear in the agreement that that's what the deal is. Um, and then if you're in construction primarily, or in a situation where a customer hires a general contractor, and then the general contractor hires subcontractors. And when you think of that, you usually think of construction. There's payment terms that are pay when paid and pay if paid. And it's a big deal. Pay if paid means if the customer doesn't pay the general contractor, then the general contractor doesn't have to pay the contractor, the subcontractor. And you're like, whoa, the subcontractor, I didn't do anything wrong. I did my work and everyone loved it. And the general contractor's like, you do good work. But ultimately, I never got paid for my customer, so I'm not going to pay you. And you're like, what? And you're like, well, that's what you agreed to. Pay if paid. I didn't get paid. I don't have to pay you. So it's a huge change, shifting of risk from the general contractor to the subcontractor. And pay when paid is, same scenario. Customer, is slow paying the general contractor. General contractor is slow paying the subcontractor. But ultimately, so that the general contractor pays the subcontractor once or when the general contractor gets paid by the customer. But in a pay when paid, the general contractor still has to pay the subcontractor within a reasonable time period. It may not be 14 days, it may not be 30 days, it might be, 6 months, whatever's that reasonable time period in your industry. So pay when paid means you will get paid, but it may take a while. Pay if paid means you only, as the subcontractor, you only get paid if the general contractor gets paid by the client. So you really have to understand that wording in a contract. All right, that is it. Um, I am done with the presentation. I am going to stop sharing my screen.
Okay, we have some questions. Here's from Narissa. She's saying pre-existing obligation. What about a contract that has a typo, but all communications related to the contract had the correct language, dollar amount, or percentage?
And I'm sorry, what was was that a question in the chat or is that somewhere else?
Yeah, that's in the Q&A.
Oh, I see Q&A. Okay.
Yeah. I assume that
Oh, I don't
this
see that.
person did not review the contract before signing it.
Yeah, then you go to the intent of the parties. If there's truly, so I'm not sure what that, but ultimately, if there is some sort of, if something is unclear, then you look at what the intent of the parties was. So in contract interpretation, if the contract obligations of the parties are clear, you never leave the four corners of the document. You stay within the four corners of the document, within the agreement, to ultimately understand what the obligations of the parties are. If it's unclear, based on the terms of the agreement, what the obligations of the parties are. Then they'll go outside the contract and look at any other what they call extrinsic evidence to determine the intent of the parties. So at that point, you're looking at what's the intent of the parties. What did they intend to mean? What was, did they have a letter of intent that correctly stated what the terms are? And then there was just a typo mistake, moving over the from the letter of intent to the actual agreement. So at that point in time, you're looking at what's the intent of the parties. Not necessarily pre-existing obligation, in my opinion, but you're looking at what's the intent. Um, what did the parties intend to agree upon? I believe.
Okay, there are some other questions in the chat if you want to look at it.
Yeah, verbal agreements are difficult to prove. Yep. What are some typical contract do's and don'ts for contract between real estate developers and nonprofit organizations? Oh, I don't even know how to answer that. I mean, ultimately, it's just make sure it's very clear what the obligations of the parties are. I don't know if it matters with real estate developers with nonprofit or for-profit organizations. It's just truly understanding what all costs and expenses are um, that is going to be involved in that project. What happens if they're as soon as you start digging, what happens if there's unknown soil conditions? Are they, do you do soil borings beforehand? What happens if it's an existing building? What happens if when you start doing your, demo work, you find, other problems. Something was not properly done originally, needs to be brought up to code. I think all those eventualities to the best possible need to somehow be addressed because someone's going to be paying for it. So yeah, I mean, like with construction matters, it's not if there's going to be a problem, it's when, right? I mean, there's a problem in every transaction when you're doing some sort of building, developing, contractor work. There's always going to be something, and you just need to be prepared, the best you can of, who's going to be responsible for, these eventualities that may occur. Um, Yeah, so then there's a question I think here about pay when paid. Oh yeah, I mean if the customer, that's just if the customer doesn't, whether it's pay when paid or pay if paid. If the general contractor's customer pays, then there's going to be no delay or hold up in paying the subcontractor. That's the pay when paid or pay if paid is just there for the eventuality of either a slow pay or a no paying customer. So. Yeah, I mean, then someone says, well, how can you verify payment isn't received? You would do that through a lawsuit. You could ask for it to be voluntarily provided, but ultimately you would that would be discovery in a lawsuit. You would, subpoena the records of the customer, the bank account records, to see if there was or wasn't a payment made from the customer to the general. And the same thing with the general contractors, banking records to see if a payment was received from that customer. So. Well, and then there's the last one, WA. I assume that means the state of Washington. You're going to have to hire a lawyer in Washington to review whatever issues you have. I'm not familiar with Washington law, especially if it's, you're going to be doing rental services to consumers. Might have some consumer protection issues you need to deal with that are unique to that state. And, there's not there at no point in time will any business be able to remove all possible liability from my business. You can try to minimize it, but at no point in time are you going to be able to make this bulletproof that nothing is ever going to come back to your business for any potential liability. There's always going to be something. Um, you're just, especially if you're dealing with consumers, there's limits as to how much your business can disclaim in responsibility when you're dealing with a consumer. The biggest issue is taking deposits, especially if a consumer, and you don't do the work. I mean, that's potential criminal issues. Um, so, you can draft contracts to try to minimize liabilities, and things like that. But ultimately, there's going to never be a chance for you to insulate yourself 100% from any type of liability. And quite frankly, that's why you have business insurance. Is if anything does happen, that you do have this insurance policy to pull on. And I do think every business should have a business insurance, and the premiums, are commensurate with the risk of your business. I have business insurance, for my business, not my operations as a lawyer, but just my business. And my premium's like $500 a year or something like that. It's very minimal because really I don't have a lot of assets, and also I don't have a lot. There's really very minimal opportunities for me to actually trigger my business liability insurance. Malpractice insurance, if I do something wrong as an attorney, different story regarding having malpractice insurance. So depends on how risky your business is, what kind of services you're providing. If you're in an equipment rental business where people can chop things off and fall out of things, probably going to have a higher premium, but there's a reason for that. And then if you ever do get sued, probably one of the biggest benefits of having business insurance, if it's a covered claim, is the insurance company will hire a lawyer for you, and your insurance policy pays those defense attorneys' costs and possibly any settlement. So it's no different than insurance for your home. You have insurance for your home, and you keep paying the premium every year, even though your home doesn't burn down. You keep paying your premium, and that's the same thing for your business, right? I mean, this is there for the eventuality of a possible lawsuit that could close your business, and so it's there for protective purposes. Um, Jurisdiction enforcement versus change of venue in a contract. So usually, a contract, a typical provision in a contract is some sort of forum selection clause. It says any dispute under this agreement will be heard in the courts in the state of Ohio. Doesn't matter if you're doing business with someone in Ohio and Indiana. Doesn't matter where the breach occurred. The parties have agreed to mutually agreed that any dispute is going to be heard in Ohio, and they usually put in it's going to be in a venue provision that says, and it's going to be heard in the court of competent jurisdiction in Cuyahoga County, Ohio. And so those are enforceable. You will find those very common in agreements. If there is no jurisdiction or venue clause in a contract, then the court will try to figure out where the contract was signed or executed, which could be tough if both parties are in different states. And then the court will try to figure out in which state did the breach occur, and then, so to some degree, it's the first to file the lawsuit and pick the jurisdiction and pick the venue. The other party could potentially file a motion to dismiss and transfer the lawsuit to a different court. But it's just going to all depend on the facts of that particular matter. I like to put in a contract that at the very end, at the signature clause, this contract was signed in Cuyahoga County, Lorain County, and then at least you have the ability to say, well, hey, this contract was formed in Lorain County. That's where we're going to have the proper jurisdiction is. And you follow that up with a jurisdiction or a venue selection clause that says, and if there's any disputes between the parties, it's going to be heard in Lorain County. Another party may say, no, I don't agree to that. I live in Indiana and I'm not agreeing to it. And you may have to, say, okay, well, we're just going to delete that clause because I don't agree to Indiana, and we'll just deal with it if that eventuality ever occurs that we actually have litigation. Um, because in general, it's very expensive to litigate. And, like 90% of lawsuits that are filed settle before they go to trial. It's just too expensive. And you may have a litigation that's a bet the company litigation that you're not willing to bet on. You'd rather settle something. So, the fact that a contract maybe doesn't have that jurisdiction or forum selection clause um, isn't the end all or be all of contract drafting, because so few cases actually end up in court. But it's good, hey, if and if the parties can't agree, then I'd probably rather keep it blank than put say, okay, I'll agree to Indiana jurisdiction, and just say, hey, why don't we both delete it, and then we'll deal with it if we get there. We're not going to not sign this agreement because of an eventuality that we can't agree upon that'll probably never happen, and then we'll just deal with it if we have to at that time. um, and so that's not uncommon, when both parties have equal bargaining leverage, to say, no, I don't agree to Indiana. Well, I don't agree to Ohio. Okay, then I guess we just need to drop that provision out of the contract, and we'll deal with it if we ever get to that point, which hopefully we never will.
Okay,
Um,
there are some open questions in the Q&A if you want to look at it.
I don't see any others.
I
I
said,
just see the
one of
one
my
about,
clients signed my contract, then came back with their own for me to sign.
oh, I see
Should
the
I try
open.
to avoid this going forward? Does their contract supersede mine? Um, Can you see that?
Yeah, no, I do. I was under the answered, I think. I see open.
Okay.
Yeah, no, I mean, if they already signed a contract, you got a contract, you don't have to sign, a new contract, right? I mean, you just don't sign anything. We already have a contract. So then if you signed another contract that in the second contract doesn't specifically override or supersede the first contract, oh boy, now you have a mess, right? And there could be a provision in the second contract that says at the end, this contract supersedes all prior agreements dealing with this subject matter. Then that provision probably revokes the first contract if you sign the second contract. Um, but I mean, you wouldn't have to sign the second contract. Now, it all depends on the terms of the second contract and, or the first contract, is it only for a month? And then after a month, then your agreement, expires as based on the terms of the contract. Um, does either party have the right to terminate with 30 days notice? And then if the other side wants you to sign their contract, and you don't, then they'll probably just give notice to terminate, and then your relationship is over. Um, so you have to see what the out clause is, what the termination clause is, and or you look at the new contract, and then you review it, negotiate the client's new contract, and make sure it's fair to you and has the key terms in it that you need. Because you may have 15 or 20 provisions in a contract, but probably three, four, five are the really meat and potatoes, really important provisions in your contract. And you probably can give or take, the remaining provisions, but there's probably three to five or so provisions in every contract. You're like, yeah, that's the meat and potatoes. I'm not agreeing to do work for you if you don't agree to those provisions on me. It's just or my positions on these provisions. And so then you like have to say, okay, well, not every provision is an A priority. Some you're like, yeah, I can give or take with that. If I get it, that's great. If I not, not going to affect me. Another one, you're like, pay if paid. I'm not agreeing to that one. Not happening. So it all depends on, the scope of the changes in the agreements and if you have any ability to negotiate. So the next question is about dealing with clients who agree to a contract and harass you a few days later. If it's a residential consumer agreement, I'd be really careful. There's a ton of consumer protection laws out there that I would really, be careful of, the consumer taking what should be, a law to protect them and then actually turning that law on its head and actually using it to prosecute you, even though technically you haven't done anything wrong, but maybe you violated a consumer protection law. So I'd be really careful. If you haven't um, incurred any debts, if you haven't foregone any opportunities, and this person doesn't want to do business with you, and you're just like, oh, okay, I haven't done started work for you. Um, I'd probably say, okay, I'll cancel the contract because do you really, from a practical standpoint, do you really want to do business with someone who already doesn't want to do business with you? And I think the answer is probably no. I would consider that to be like bad money, right? They're going to take up more time and effort from you and possibly detract you from doing work for other paying clients than, having this disgruntled client. So I think it's different if you've already started buying materials that are unique to this project, you're not going to be able to use again. You booked an appointment and you don't have other appointments for that day. That's a little different. You may charge a breakup fee or something like that, but that should be clear in the agreement. But my suggestion is generally, if someone doesn't want to do work with you, you probably don't want to do work with them. It's not worth it. Um, and I consider that to be what a business coach I would, refer to as bad money. It's just not worth your time, effort, and energy. As long as you haven't incurred a bunch of expenses and costs, I'd say if you're not happy, it's not in the agreement, but I'm just going to terminate, let's move on, and then, potentially negative, social media reviews, right? That could be a killer, right? And granted, it has nothing to do with the contract, but it's the practical reality of the matter that you really have to look at all aspects of this relationship. So, like I had one person say, this was back in a presidential election, person lived on Facebook. The contractor lived on Facebook, said, this is who I vote for. And if you don't vote for me, I don't even know if you should be alive. Right. I don't know how you exist. And one of the person's clients was like, well, I'm in the group that you say shouldn't be alive. And I'm going to terminate with you. I don't know how I can do work with you if that's the way you think of me. They're like, well, you breached. And I'm like, and I talked to the contractor. I'm like, what are you doing? like, unless if you're in a very unique situation where all your clients are of the same ideology, whatever it may be, like you're alienating people that you think you can say whatever you want on the internet. And like, and now you have real ramifications of this. I'm like, the person may be in breach. I go, but you should watch what you say. So anyway, um, all right, I think we're out of time. So, Anita, do you have anything else?
Okay. Again, if you don't mind, Chris, if people want to send us, or if you want to put in the chat, put your email address if they can ask you questions.
Sure.
Um, or if you prefer not to, that's
That's fine. If
okay.
they have questions, I'm happy to chat.
Okay, thank you.
You're welcome. And congratulations. I do applaud everyone for attending because it's starting up a business is a big deal. And the more information you can get, the more educated you become and the fewer, you know, mistakes are made. The mistakes are smaller that are made, shorter U-turns. So it's important to have the best you can build your foundation. Um, so
Yes, and I would just reiterate, before you sign a contract, have it reviewed, because once you sign it, you are obligated. And I have had clients that have really been burned by signing something and then realizing after the fact that they're responsible for something that they weren't aware of. And it can put you out of business. So,
Or, if it doesn't put you out of business, it could really cramp future expansions. Um, you know, Going into a new service field, you may not expect that you have this expense, and you're like, I had that money saved away for buying more inventory, whatever it may be. It could, whether it puts you out of business or just has a large, a negative impact on your business is very real.
yeah. So again, Chris, thank you so much. It really appreciate your insights and your expertise.
Yep, you're
So,
welcome. Always happy to help a score. You guys have a great organization.
okay, enjoy.